Minerva Mills. Now, what is the consequence of the decision in Minerva? Does that only strike down the expansion of the ambit of 31C to all directive principles?
Yes.
Or does it leave intact 39B and C? Now, if your contention is the latter contention.
Yes.
39B and C, it still continues to be valid. But is it not important that we deal with that and decide it?
But the difficulty is, neither anyone has addressed that your lordships can permit assessing. We have also not examined from that point of view, because according to us, and at the outset, I pointed out that the controversy before this bench is limited.
But you know what's going to happen is this will go back right away before 7 judges to argue that. And what we are doing is we are dealing with the offshoot, namely 39B and C,
Yes.
without dealing with the mother, which is 31C.
But
If 31C, if they are right, for a moment, hypothesis, if they are right that 31C does not exist on the Constitution today by virtue of the judgment in Minerva Mills, then whether the law is protected under 31C as giving effect to 39B and C does not arise at all.
correct, my lords, but nobody has doubted that proposition, which may, give rise to a re-examination by the larger bench.
The first referring order specifically raises this as Mr. Nariman's argument. In the second and third referring orders, what happened was the focus shifted to
39B.
39B and C. But the fact that Mr. Nariman, and he's observing us from heaven, the fact that Mr. Nariman raised this issue about 31C is squarely a part of a referring order. And that will have to be decided by 7 judges at the minimum.
Five.
Decided by 7.
By
you know,
Five, my lord.
No,
By
it has to
7.
go before 7 because it has been decided by 5.
It is 3.
By a
The
bench
first
of 5.
reference is 3.
No.
Minerva Mills is 5.
Minerva Mills is 5.
Minerva Mills is 5.
Minerva is 5. Vamanarao is 5.
This is the first question.
This very question has been referred by 5 to 7.
My sister just with her permission, I'll just read out. The first question which Mr. Zal had raised yesterday was whether 31C of the Constitution survives after the judgment of this court in Minerva Mills, reported in so-and-so, striking down Section 4 of the Constitution, 42nd Amendment Act, 1976. Briefly, what they are arguing, they're not saying that they are right. They say that when a constitutional provision is substituted by a constitutional amendment, and that substituted constitutional amendment is struck down, that does not result in the revival of the original provision.
Yes.
Your answer to that would be, and I presume it, we have not heard you, is that when a constitutional provision is substituted by another constitutional provision to expand the ambit of that constitutional provision, then the striking down of the subsequent constitutional amendment on the ground that the expansion was unconstitutional.
The remaining part remains.
It will not affect the original. It will not be, because this was not an absolute substitution. This was an expansion of the ambit of the protection which Article 31C gave. And the original provision having been upheld in Keshwanand Bharati, surely the impact of a subsequent smaller bench of 5 cannot affect the validity of the provision in Keshwanand. That's your argument. That's the point that we have to deal with. But, honestly,
It was our argument, presuming 31C to be the subject.
Yeah, because on your argument on 39B presumes that 31C is valid. Now they are raising an issue as 31C is not valid.
Well, they are raising, my lord, but the court has never, my lord.
I agree with you.
Your lordship, my lord, I can say one thing.
First referring order itself refers to this.
But my lord, thereafter, that is given up, my lord, by every larger benches. Your lordships, my lord, sitting in this combination.
Given up, actually.
My lord, your lordships, in my lord, one line answer. In this combination, your lordships can take up, my lord. I am not on that technicality.
Even if the Attorney General or the Solicitor General is to say today that he is still there, then there will be a question by somebody as was done that it is a matter of concession. So should there not be a clarity on what is a very significant part of the Constitution?
Let us, my lord, have, my lord, the
one thing, of course, the other side, as the Chief Justice has rightly said, they have not had the opportunity. In fact, the discussion which is emerging today might have taken them a bit of a surprise. So I think that will have.
But all of,
Actually, you know, what happened was yesterday,
One more thought.
you know, yesterday, Mr. Andarjuna was ready on 31C. Mr. Devarajan was to argue 39B. We tell, and Samir also, we told them that we are not going into 31C. So they
and
were
my lord,
also-
we were,
they
and my lord,
we
I'll
put
just
the cat
add.
among the pigeons yesterday, you see, so that's why they were.
My lord, and I would add, we were ready to persuade your lordships that 31C does not arise, and we could.
Mr. Solicitor, we are more than willing, amenable to persuasion that look, 31C does not arrive.
Look,
That the argument of Mr. Nariman in referring order 1, there's no substance in it. Please don't. But then we can at least say, if you're right on that, we will say that the continuation of 31C is now a concluded doctrine in our jurisprudence, so that we lay it down for the future, if you're right. That, you know, 31C, that there is no though it was raised by Mr. Nariman, and that was the basis for one of the reasons for referring it to bench, a larger bench, and referring order 1, that there is no substance in it. And then, you know, that attains finality unless somebody decides to refer.
Can we, my lord,
for it, you know?
First part of
One
In which
thought.
can we respond, my lord, after consulting?
In which case, after we've heard your submissions on 39B, we'll hear them on 31C. Mr. Andarjuna has broadly argued it. And then we'll hear him, you know, intensively for a couple of hours and hear your response on it.
One thought process. Regardless of 31C. If 31C has not even invoked 39,
Sorry?
if 31C has not referred to 39 at all, I'm just looking at it. Now, the law is that the directive principle state policy, any action, state action taken in pursuance of state policy, are presumed to be in public interest.
But 31C refers to 39B and C.
I close my eyes to 31C for a minute.
Yeah.
So 39B will still be a support, a framework of support for sustaining this law, without reference to 31C.
That I said when I was explaining it.
That's right.
It should be reasonable.
Exactly.
That I said right
So
after.
it's only
That
all
even
these.
if the law is not protected by 31C, the fact that the law is in furtherance of 39B and C is an index of its reasonableness, isn't it?
Therefore, whether the court should go into a 31C argument.
But 14 and 19 would be excluded if 31C protects the law. Then they will argue everything else, 300 and A and, you know, 921 and all. That's then their nature of the challenge is constricted then before the regular bench.
And if I can just add, the second
Yeah,
reference
I-
order also mentions the 31C issue, that is 5 to 7 also.
Why it's going into a 31C, I understand the reason, the raison d'etre why the court would like to put an end to any controversy whatsoever. But I think we need to
You see, what
address the
happens
court
is
on a very
as
larger
As
framework.
Samir is saying, the second order refers to 31C. The reference to 9 comes about only because of
Mafat
Ranganath Reddy being 7 judges.
That's right.
and
Right.
Mafat Lal.
But therefore, part of the
And
challenge.
Mafat
Mafat Lal, 9
Lal being
judges.
9.
Mafatlal.
Mafatlal being 9. But they didn't refer it to 11 for the reason that Mafatlal, that observation is obviously an obiter.
No, my lord, it is not, my lord, please don't say. That's our argument. We will persuade your lordships, it is not an obit.
Mafatlal are invited to get into.
Lord, your lordships have possibly preempted our argument. And my lord, the reasons are simple. The Attorney General argued, findings are recorded, and obiter is not dealt with by the concurring or dissenting judgment. Even the dissenting judgment deals with it.
So the attorney must do justice to it now.
All right. Therefore, we take your argument that, you know, Mafatlal concludes it. Therefore, 9 will deal with 39B and C, but their argument on 31C will have to be dealt with by whom? Somebody will have to deal with it by at least 7.
Lord, we are before the Honorable Chief Justice, bench presided by the Honorable Chief Justice. Lord, no technical arguments can weigh.
Say that, look, my argument on 31C has to be, somebody has to answer it. 5 can't answer it.
Correct.
After we decide this matter, they'll say, now refer that to 7. So after this round, again it will go back to 7.
My lord, correct, my lord, but thereafter,
Stop them from having their day in
Lord,
court.
thereafter the bench is larger benches than, my lord, the one which referred, my lord, felt that it is not necessary. It's not that, my lord, without,
It's not rejected. You see, the 7 judges, while referring it to 9, didn't reject the 31C argument which they are making. They just referred to this
by
because-
non-referring, they have rejected, my lord. My lord,
No,
they had an option of referring everything.
31C will have to deal with that.
The reference is by implication. Cannot. Not referring to 31C over and over again.
No, my lord, there were 5 issues. They refer 4, meaning thereby, my lord, they have not referred the 5th.
We settle it. We'll have to deal with
Lord, your lordships can settle several issues which might even incidentally arise academically. Academically, my lord, I can raise 5 issues.
So we'll have to go.
Lord,
to
I
Minerva
can-
Mills, actually. What
Lord-
is the ground on which Minerva Mills struck down 31C? If Minerva Mills says, as I believe it does, that this expansion of 31C to include all directive principles is unconstitutional, then Minerva Mills has left the substratum of original 31C intact.
As affirmed by Keshavananda.
No, Minerva Mills is
Second,
subsequent
And
to
look at the consequence of other.
Correct, but Keshwanand Bharti is 13 judges, my lord.
Another thing, Mr. Solicitor, look at the consequence of, suppose we were to accept their submission, that 31C is not in the statute book today, right? All that it means is what? What is the consequence? That Parliament will have to bring about an amendment to reinstate the original 31C, which has been upheld by Keshwanand Bharti, which is what you are suggesting.
My lord, it's not that, my lord, your lordship knows, my lord, on the practical grounds,
No,
it's not.
practical- No. We are not on the practical aspects. We are on the constitutional aspect. This does not prevent Parliament, no. Parliament can just, can revive and restore 31.
My lord, let us, my lord, confer and respond.
So,
but, my lord,
even assuming that
academically-
it's a question of the process, following it again.
My lord, the academically, my lord, we can raise 5 more grounds, my lord. Would the honorable 9 judges bench, my lord, invest time on something which is not referred? But, my lord, we'll respond, my lord, after.
It's part of the whole, both the questions. Yeah.
According to us, it is not, my lord. I can again persuade your lordships that 31C is not very consciously referred to the larger bench.
All right, what we will do is this. They are virtually completing their arguments on 39B. Now, Ms. Babar is arguing, one or two more counsel, 5 minutes we're giving them. After they have concluded that, you address us on, of course, their submission on 39B. And please tell us, argue on why the 31C issue does not arise before the 9-judge bench. Not on merits, not on merits.
Lord, I already did that, my lord, and your lordships were, according to me, persuaded.
You can take 10 minutes, you can argue that.
No, in other words, what is the consequence of the judgment in Minerva Mills?
Correct.
On
No,
31.
that is not really the question, my lord, which is troubling my lord, the Chief Justice.
Because
I don't know why there is some little reluctance.
No, reluctance.
The judgment.
There is no reluctance on our part, my lord. That means, my lord, few more weeks. That's the only.
2 more weeks, I mean, 2 hours on their side. 2 hours.
that reference came 27 years ago. Now, the judgment which have come after that have clearly put that reference to rest tangentially without having taken up the question, but clearly it's been answered.
And tell us that,
The NJC judgment covers it fully.
Yes, my lord.
but then if you are right on that,
Yes,
please
then-
tell us that so that when a bench of 9 puts its finality, there is a certain degree of finality in the law, which is good for the nation. It's good for the
My lord, I'll first address on that. But NJSC, in my note which I read yesterday, I didn't read it. My lord, I have quoted NJSC
That's
paragraph.
what we are saying, that please show us that, because then there is some degree of finality for the
No,
High
there is
Court.
no reluctance, my lord, kindly appreciate, but there is no reluctance before a larger bench, that too presided over by the Honorable Chief Justice of India. No technical plea referred, not referred, would arise, my lord, can be raised.
See, as we told even Mr. Andaruna yesterday, we stopped him we said, look, we are not going to reconsider the validity of 31C based on Coelho, because that has attained finality in Keshwanand Bharti. We want that to stand. We don't want to open up the canvas, because in constitutional matters, just needlessly opening up the canvas can cause grave constitutional uncertainty. We'll be the last to do
Whenever
that.
your constitution comes closer to 13 judges, that makes all of us nervous. So we'd like to keep that as a.
Well, 9 is not very far from 13, that's what he wants.
absolutely. So, you know, yeah, let-
reference to 30.
there's a great deal to be said in
Not to be
the
50.
sense of stability and continuance of the same position of law. No position of law is perfect. Stability in a nation is very important, even in the constitutional fabric. So yes, we'll hear Ms. Babar now. She'll conclude
But we will address on, my
and
lord.
address us on why the 31C does not arise in.
And my lord, with a caveat and with a clarification, there is no reluctance to answer that question. Genuinely, my lord, it doesn't arise. That's the.
Actually, just,
that would be now necessary is took away the sale yesterday from the argument that was to be advanced.
Lordship.
So all that will be necessary now is to take into account that this argument is also being advanced.
Lordship.
So Ms. Babbar is on her legs. She will have to tighten her belts, raise the bar a little bit like they do in high jumps, and then also take in the argument of 31.
Lordship. We'll do that.
Yes, your lordships. We would
What
request,
now you've shown us both Justice Krishnayas and
yes,
Justice Untwalia,
and that the argument, and the fact the arguments of Mr. Sen were rejected solely on the strength of the judgment of Justice Krishna Iyer.
Lord, in that
That's the
case,
other
well,
point
let
I-
them finish everything and we argue everything. Rather than
Lordships,
doing
we
it,
have the right to open as far as 31C is concerned.
That is there.
is there.
But I am here, my lord. I would prefer this matter of great importance to argue in person, my lord. I'm very sorry, my lord. I
Place that you are sitting in,
yes, my lord.
is it the same chamber that your illustrious father used to sit?
Lord, in fact, the very spot that I'm sitting in is that spot. So, Lord, your lordship is absolutely right, Lord.
Very, very, very important and significant chair, if I must say so, in the judicial firmament.
Lord, I am deeply honored by your lordship saying that.
Should be more effective if he addresses from that chair.
Lord, I leave it up to your lordships, Lord. But Lord, I am actually heartened to hear that your lordships will hear me on the 31C point. Lord, my only request would be, Lord, since the matter is of such importance, Lord, I would prefer to be there physically. I think the schedule would permit that I will be there tomorrow morning. with your lordship.
You guys fully seized the matter, and we've heard the most significant matters, online. There's no difficulty. If you feel that you've been handicapped or you've been handicapped, we'll give you a little accommodation, no problem.
I'm deeply obliged, your lordship. Deeply- I'll be there first thing in the morning for this argument. If that suits your lordship.
We'll see, as soon as they conclude, you be mentally prepared that, we'll start with 31C once Sundara finishes.
39B first and there. Instead, my lord,
Would you
let,
like to respond to 39B first?
my lord, Lord, what all of us are, my lord, head item is, let them argue everything.
All right.
We also respond in everything.
Fair enough. That's better. Yes, anything else now?
Yes, just a few short.
But we'll
points.
have to update our notes also suitably. Right.
It's only on notice. Uploaded everything.
May I just inquire, Lord, 31C will be after the 39B arguments conclude?
No, well, that would be too piecemeal, my lord.
We'll start immediately after the next two lawyers are done. We'll hear you immediately. We'll start with that.
Very good.
Start with your,
Very good.
and then Samir is also there. Samir Parekh is also there.
Very good.
We have, we'll do it. We deleted that 31C arguments from the written notes also. We'll just have to make that adjustment and.
In the electronic world, you always leave footprints behind.
Yes.
Yes.
I'll just summarize. So lordships, if your lordships please takes Article 39, the Bear Act. property of an individual as a fundamental right. So 39B is part of the original constitution. So when the origin of the constitution is with 39B in part 4 of the constitution and article 31, which is removed subsequently in the 44th amendment. So article 31, at the point of time, this was framed by our constitution makers. They were cognizant of the fact that article 31 existed and recognized a fundamental right to property of the individual. So what I'm saying is, if you have to today read as what was the intention of and there is, the problem is, your lordships, that there is really no material, there are no judgments except Justice Krishna Iyer's and those that follow Justice Krishna Iyer with respect to article 39B. That's the handicap.
Well, I mean, at a jurisprudential level, this case does require a lot of explanation by the court on what do we understand by the concept of resources for the purpose of the directive principles. As I said, you have two extreme views: the capitalist view, which regards all resources individualistic. You have the socialistic view, which regards all resource as of the community, and you have the Gandhian ideals, which are imbued in Part 4 of the Constitution, by which we hold our resources as a matter of trust for others. You know, that there is a nuance which we'll have to, which is
So,
no
Which
case.
is the limited,
we'll
yes,
have to
the limited points that I'm making, your lordships,
community.
are one, the fact that there are different vesting provisions. 31A exists. So all the point that I'm making is just this, that the vesting does not happen in terms of 39B. That's the limited point. So it doesn't take away from the fact that if the state deems it fit.
Right. 39B is not a provision for either acquisition of a vesting.
Yes, that's the limited point.
Statutory, as they say.
That's the limited
Yeah.
point.
It's only a goal.
Secondly, if it does not deal with acquisition, then surely there can't be a deemed acquisition under 39B. So 39B as a condition precedent would require an acquisition. Lordships, that would be very dangerous because that would amount to an acquisition in terms of 39B, when 39B presupposes that there is already a pre-existing acquisition, and all that 39B does is it distributes so as best to subserve the common good. That is the obligation and the goal in terms of 39B. So
in order to distribute, acquisition may be necessary.
yes, but that can't happen under 39B. So
And the first step to
absolutely.
distribute.
Absolutely. The only limited point that I'm making is that the acquisition does not happen in terms of 39B. There is already, that's outside 39B. And secondly, how can you distribute something which is not owned? How can you distribute something which does not belong to you? So if your lordships want me to skip the definition, I'll just make the page reference is page 840 of volume 4A. I'll just hand over we have filed these, your lordships, and also emailed it, but there is some difficulty. We'll just place this.
A very substantial point, no doubt about it. I mean, absolutely. There's a very fundamental and profound point which you have made. You have to deal with it properly.
Yes, lordships. So if I may just hand over, there is a certain aspect.
Raising it, and you've raised it very, very coherently and very succinctly. You have raised.
I'm so grateful. I just have one document which I want. It's already a part of the compilation, but this is a PDF version. It's easier to read. So I've put this together along with my written submissions. It's been e-filed, but there's certain aspects. There was an amendment proposed to the draft constitution.
Oh, you're on the Constituent Assembly debate?
Yes, you're
Not
right.
actually, because that's something we were yesterday saying. Yes, but by the way, Israel was saying yesterday, and Jamshid was also saying nobody showed us a COD yesterday.
Yeah.
वो बंद करो।
13. This is the start of the volume, Constituent Assembly Debates. And this particular debate is of 22nd of November, 1948.
Yes.
So if your lordship sees page 21 of this, come to page 21. The middle of the page, where it says Mr. Vice President, after Naziruddin Ahmad, Mr. Vice President, then 885, Professor K.T. Shah. So this is the amendment number 885 proposed by Professor K.T. Shah. Professor K.T. Shah, Mr. Vice President, sir, I beg to move that for clause 2 of Article 31, the following be clause 2 of 31 is identical with 39B. We have put the clause of the draft Constitution 31B also in the compilation, but you'll also take it from me, it's identical with 39B.
It's there,
That's quoted,
which is
quoted.
quoted there.
Noted just below.
Yes.
That is the substitution which you wanted. Substitution.
And secondly, this is referred to as Article 31, subclause 2, and that's the same as present 39, subclause B. The proposed amendment is what is now quoted, that for clause 2 of Article 31, the following be substituted. That the ownership, control, and management of the natural resources of the country in the shape of mines and mineral wealth, forests, rivers, and flowing waters, as well as in the shape of the seas along the coast of the country, shall be vested in and belong to the country collectively, and shall be exploited and developed on behalf of the community by the state as represented by the central or provincial governments or local governing authority or statutory corporation as may be provided for in each case by Act of Parliament. So one significant feature is that it specifies the kinds of natural resources. And the second significant feature is that it provides that these resources shall be vested in. Rather than using the word distribute, this proposed amendment brings in the phrase vested in and belong to the country collectively. May I just read that again, Your Lordships? At page, the third line of the amendment uses the phrase shall be vested in and belong to. And if Your Lordships comes to the third line from the bottom, I suggest, therefore, that it should be substituted by what I have just read.
Previous part also. Sir, the original clause.
Sir, the original clause for which I propose this one in substitution stands as follows. Subclause 2, that the ownership and control of the material resources of the community are so distributed as best to subserve the common good. I'm so grateful. That's verbatim identical to 39B. And then if Your Lordships comes to the third paragraph from the bottom, I suggest, therefore, that it should be substituted by what I have just read out, whereby the ownership, control, and management of the natural resources shall be vested in the community collectively and shall be exploited, developed, and worked by the community as represented by the central or provincial or local governments or by any statutory corporations that may have been created for the purpose. I think there can be no dispute on this proposition that as regards the natural resources that I have tried to describe, no human being has lent any value to those resources by his or her own labor. Your Lordships, we turn to the next page, page 22. Again, the third last paragraph. It is high time, therefore, page 22, third last paragraph. It is high time, therefore, that in this constitution we lay down very categorically that the ultimate ownership and direct management, conduct, and development of these resources can only be in the hands of the state or the agents of the state, the representatives of the state, the creatures of the state like provinces, municipalities, or statutory corporations. And thereafter, page 31, at the bottom of the page 31, Shri Jaduvana Sahaya is the member who's addressing the Constituent Assembly. And on the next page, page 32, this is what he says about this clause. Fourth line from the top. I most respectfully submit that in this chapter, Article 31, that is the same as 39, is the pivot around which everything will revolve. Article 31, clause 2 is the most important feature for which I shall most respectfully draw the attention of the House, but it is not possible for me, I'm sorry, to support the amendment moved by my friend Professor Shah outright, because I respectfully submit it is loosely worded. But I may state for the information of the House that so far as the principles which underlie his amendment are concerned, I support them. The spirit of it also I support. I fail to see why this august assembly, which meets only once in every country, is not keen to the extent of clearly and boldly incorporating in this article that the means of production and the natural or material resources of the country shall belong to the community and through it to the state. I can understand this. And the last line of that paragraph, I cannot understand how it is that the Congress, the predominantly majority party here, is not pressing this thing. And ultimately at page 33, bottom of the page, this is Dr. Ambedkar. Just that last paragraph on page 33, with regard to his other amendment, he's referring to Mr. K.T. Shah's amendment, namely substitution, page 33, last paragraph.
Yes, that's important.
With regard to his other amendments, namely substitution of his own clauses for subclauses 2 and 3 of Article 31, all I want to say is this, that I would have been quite prepared to consider the amendment of Professor Shah if he had shown that what he intended to do by the substitution of his own clauses was not possible to be done under the language as it stands. So if I may just pause here, Dr. Ambedkar is clearly referring to
This is what Professor K.T. Shah wanted to do by amendment is already there in this clause.
yes, and he's clearly referring therefore to the, I'll just read the complete portion of what he says, was not possible to be done under the language as it stands. So far as I'm able to see, I think the language has been used in the draft in a more extensive language, which also includes the particular propositions which have been moved by Professor Shah, and I therefore do not see the necessity for substituting these limited particular clauses for the clauses which have been drafted in general language deliberately for a set purpose. I therefore oppose his second and third amendments. So the first line at page 34, for substituting these limited particular clauses, so here he's clearly referring to that part of the amendment which specifies the resources, which refers to mines and mineral wealth, forests, rivers, and seas. That's the part which he does not really agree to, because he says that the original draft is more broad, and let's leave it at that.
What was thought was only with regard to natural resources.
Yes.
But
So
they said it's more expansive.
yes, the draft as such. This is the only discussion. There is no discussion really on the vesting, the clause on vesting, which was also proposed by him. There is no discussion, at least here, as far as I can see. So therefore, the fact of the matter is that there was an amendment which inter alia proposed an amendment which incorporated the word vesting and which was not adopted. Therefore, today, the word distribution has to be given its meaning. There cannot be vesting under Article 39B. 39B would only come into the picture after the property has vested in the state, and the state is at the stage of distributing these assets. That is the only point of time where Article 39B can be invoked, and cannot be invoked in support of legislation that are vesting property in the state from private bodies, or where the property is being acquired. That's all, Your Lordships. I'm so grateful. Lordships, before I part, in the tradition of the senior Mr. Andhyarujin, I'd just like to thank Daisy, Hannah, Oindrila Sen, and Rayana Mukherjee for all their contribution. Grateful.
May it please, please. Lord, I appear for. For individual house owners whose houses, my lord, are subject to standard rent provisions. And for the, yes, my lord, there are, my lord, the Chief Justice has very clearly, my lord, placed the bar which your lordships are going to consider. Lord, my first respectful submission is that if we look at Article 39B from the point of view of Article 31C, we are, my lord, going to get a distorted view. One reason, of course, is what my learned friend said, that at the beginning of the Constitution, 31C was not there. So your lordships, my lord, if your lordships were to look, there is, of course, a link between 31C and 39B. But if that is going to be the starting point of inquiry,
39B cannot be interpreted from the lens of 31C.
and my lord, this is relevant because all the nationalization cases that your lordships have dealt with in the past, those are all very extreme cases where there's a complete taking of certain establishments, industries, etc. And then in that context, my lord, a justification is given by the state and your lordships will approve it. But at the dawn of the Constitution, all these provisions were not there. And like my learned friend pointed out, Article 31, Article 19(1)(f) were coexisting with Article 39B. So, my lord, if that is the situation, and the second point, my lord, would be that Article 39B has never been construed as a vesting of legislative power. There's a 5-judge bench decision of your lordship saying very clearly that if at all we're talking about acquisition or requisition, etc., there are very clear entries in the Constitution that power is always there. So in the context of acquisition and requisition, entry 42 of list 3 covers the area. In Ishwari Khetan's case, my lord, your lordship said that the state doesn't really have to bother too much subject to the definitions of industry, etc. The power is always there. And my lord, even independent of that, the power of eminent domain is a concept which is so very well known in this Constitution that there is no doubt that if the government of the day wants to take over any property whatsoever, there is nothing really fettering them except Part 3 legislative competence and not all the usual restrictions. So 39B would therefore not be seen as the source for the government or the parliament to do certain things. It is, there is no doubt about this throughout the, the interpretations of your lordships. So if
Directive principle, which is fundamental in the governance of the country.
I'm grateful.
It is a principle.
It is a principle, it is the purpose. But
It's of power.
that's right, which is why my lord, the Chief Justice said that if any of the laws, forget only 39B, my lord, any directive principle of state policy, if it is sought to be given effect to, of course, it's a reasonable thing to do, provided always the nexus, etc., are clearly laid out. So, my lord, we also cannot put it to so high that private property is off bounds at all points of time. That cannot be, my lord. But for that, 39B interpretation is not going to be the starting point or even the ending point. 39B is a purpose. For achieving that purpose, there are other powers that the government always has had. Exercise those powers and then see, my lord, whether 39B is one of the objectives that is sought to be fulfilled. And why stop only with 39B? There are other directive principles also. So, my lord, in this context, how exactly are we supposed to look at a directive principle of state policy? What is the importance to be given to it? What is the primacy to be given to it? And what happens when a directive principle of state policy collides with a fundamental right? And not there is a wealth of jurisprudence of your lordships on this issue that something like a directive principle or a fundamental right part, they should never be so construed as to conflict with each other. They should be construed harmoniously. And I can do no better, my lord, than to place my proposition in Minerva Mills. My lord, the Chief Justice, Chandrachud had very categorically placed the contours of the debate. And Lord, if we look at Article 39 from that perspective, then Lord, much of the apprehension that the government would like us to believe that if there is an interference with 39B, we will lose a lot of ability to do certain things, Lord, all that will be washed away. So Lord, may I very quickly place paragraph 56 and 57 in Minerva Mills, volume 5, page 2050. At page 2079. But there are two paragraphs which I really need to place before your lordship. So just to provide context to my submission, that please do not look at 39B from the point of view of 31C. There is another much more primary, much more primal, much more important way to look at it. And that, my lord, is crystallized in this judgment. Para 56, may I place it? May I? No? Sorry, it's page 2079 in volume 5. May I please? No? My Lord, just a moment.
Yes.
Yes. Para 56. The significance of the perception that parts 3 and 4 together constitute the core of commitment to social revolution, and they together are the conscience of the Constitution, is to be traced to a deep understanding of the scheme of the Indian Constitution. Granville Austin's observation brings out the true position that parts 3 and 4 are like two wheels of a chariot, one no less important than the other. You snap one and the other will lose its efficacy. They are like a twin formula for achieving the social revolution, which is the ideal which the visionary founders of the Constitution set before themselves. In other words, the Indian Constitution is founded on the bedrock of the balance between parts 3 and 4. To give absolute primacy to one over the other is to disturb the harmony of the Constitution. This harmony and balance between fundamental rights and directive principles is an essential feature of the basic structure of the Constitution. And then, my Lord, the Chief Justice expounds on this. This is not mere semantics. The edifice of our Constitution is built upon the concepts crystallized in the preamble. We resolve to constitute ourselves into a socialist state which carried with it the obligation to secure to our people justice, social, economic, and political. We therefore put part 4 in our Constitution containing directive principles of state policy which specify the socialist goal to be achieved. We promise to our people a democratic polity which carries with it the obligation of securing to the people liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and the assurance that the dignity of the individual will at all costs be preserved. We therefore put part 3 in our Constitution, conferring those rights on the people. Those rights are not an end in themselves, but are the means to an end. The end is specified in part 4. Therefore, the rights conferred by part 3 are subject to reasonable restrictions, and the Constitution provides that enforcement of some of them may, in stated uncommon circumstances, be suspended. And here is the pivotal part. But just as the rights conferred by part 3 would be without a radar and a compass if they were not geared to an ideal, in the same manner, the attainment of the ideal set out in part 4 would become a pretense of tyranny if the price to be paid for achieving that ideal is human freedoms. One of the faiths of our founding fathers was the purity of means. Indeed, under our law, even a dacoit who has committed a murder cannot be put to death in the exercise of right of self-defense after he has made good his escape. So great is the insistence of civilized laws on the purity of means. The goals set out in part 4 have, therefore, to be achieved without the abrogation of the means provided by part 3. It is in this sense that parts 3 and 4 together constitute the core of our Constitution and combine to form its conscience. Anything that destroys the balance between the two parts will ipso facto destroy an essential element of the basic structure of our Constitution. So, my Lord, now, if we look at 31C, which is essentially a power in the arsenal of the state to acquire, to completely take away, then, my Lord, Article 39B looks like a bulldozer. But Article 39B, your lordships have always felt, is a control on the power of the government. In the natural resources case of the presidential reference, your lordships have expressly said so, that 39B is a limitation on power. But if you look at it from 31C, then it looks like it is a very formidable power. But if the matter is looked at according to paragraph 56 and 57, and these observations have also been reaffirmed by the Rhine judges bench in Coelho's case. I'll place that paragraph before your lordship. So there is no doubt, my lord, that this balance between part 3 and part 4 is a part of the basic structure. If that is so, my lord, then Article 31C should not be definitive or determinative of the way in which 39B is to be construed. Firstly. Secondly, my lord, Article 31C, your lordships are very well aware, is a very peculiar article. It is in part 3 of the Constitution dealing with fundamental rights, but actually it is a Trojan horse. It takes away the fundamental rights. So how can that provision be part of a balancing equation between part 3 and part 4? It will lead to a distorted vision, which is why, my lord, Mr. Sen's argument in Sanjeev Koko is very clear that when you look at 39B, distribution presupposes something to distribute. That's something to distribute. There is no fetter on the power of the government. Why the apprehension is coming is because 31C provides an immunity against the challenge on Article 14 and 19, which the government of the day does not want to answer of any day. And therefore, my lord, from this perspective, if we look at 39B, my lord, we will come to a wrong result. So with that, my lord, may I immediately take your lordships to what is the balancing that Article 39 in fact talks about. We'll keep the fundamental rights on one side, but 39B, my lord, in my respectful submission, is in continuation and part of, paired with, coupled with Article 38. One cannot be read without the other. And my lord, the use of the word in particular in Article 39, to some extent, my lord, helps my argument, but more importantly, the manner in which Justice Chandrachud has, Honorable the Chief Justice had interpreted it. 38 provides the bedrock, and 39 provides a further mechanism to give effect to it. Lord, please see Article 38 before we get into Article 39. Now, my lord, Article 37, lordships have seen that they are not enforceable, but my lord, we have come too far away. They are very important directive principles of state policy. My lord, we should not dilute the importance of that. Question is, to what extent does it justify a certain exercise of power? And if an immunity is sought to be claimed, my lord, whether your lordships will permit it or not. So Article 38, my lord, the language of Article 38, my lord, there were two amendments. The state shall strive to promote the welfare of the people by securing and protecting, as effectively as it may, a social order in which justice, social, economic, and political shall inform all institutions of national life. Then, Lord, subclause 2. The state shall in particular strive to minimize the inequalities in income and endeavor to eliminate inequalities in status, facilities, and opportunities, not only among individuals, but also amongst groups of people residing in different areas or engaged in different vocations. Lord, here I may just emphasize.
Came by the 44th Amendment.
That's right. Absolutely. Now, my lord, what is even the 44th Amendment focusing on? It is equality of status, facilities, and opportunity. It is not an equality of result. If I may explain this point. Every person, every citizen should have an equal opportunity to lead a better life. Provision of that opportunity is not the guarantee of an equality of result. Everybody who works hard is not going to succeed in life. Everybody who's got money may not get a certain commodity, whether he likes it or not. There is no equality of result which is guaranteed by Article 38. Now, this is very vital to understand Article 39.
There is one important.
Yes, ma'am.
As Chief was pointing out yesterday, 38 is this big, 39 is smaller.
I'm obliged.
Difference is that 38 is not protected by 31 capital C.
That's right.
As they would like us to read capital 31.
That's right. But
That's a major difference.
yes, and that is exactly the canvas of this debate, that the parliament or the state legislatures want to provide.
39 only. But 39, 38 will not get that protection.
My respectful submission is that 39 is in species with 38. So
39 is illustrative of 38.
I'm obliged, my lord. So that becomes very clear immediately in Article 39. The state shall in particular direct its policy towards securing. Now, my lord, if there was no umbilical cord between these two, this word in particular, this phrase in particular is an unnecessary addition here, because my lord, it is perhaps a non-statable proposition that parliament or legislature can make a law which goes contrary to what is written in Article 39. There will be no law, my lord, which will be passed to
indicate that the state may follow certain other policy goals. But these have been emphasized by the Constitution.
I'm obliged. And the larger policy goals are in 38. Now, my lord, this is where, my lord, this is Julia's question.
Beyond 38. 38 also may not be. 38
My lord,
is broad. It says that social order in which justice, social, economic, and political shall inform all the institutions of the national life.
My lord, here, the argument is that if equality of status, equality of facility, equality of opportunity is the goal, it is not equality of result, then you are empowering the dignity of people by saying that I will create the circumstances in which you can do your best, but beyond that, don't expect a result from the government. And that Article 39B, my lord, is exactly towards that the material resources of the community are so distributed so as to subserve the common good. So if your lordships were to interpret this in a manner that enhances the dignity of individuals, then, my lord, the meaning would be that acquisition or taking away a right. Lord, just as a footnote here, I am aggrieved by the rent control measures. There, my lord, it is not my property that is being taken away. There is a restriction put on my right to charge a rent. That restriction says that you can't charge more than the standard rent. Now, my lord, the Chief Justice had mentioned that a right to a property, like for instance, the pen or this book, this is my right. But my lord, the Hoffeldian analysis says that my right to property is not just my right to this thing. Along with it, there are a number of other rights which are built into it. My right to preclude somebody else from it, my right to charge, the right to capital, my right to charge for this particular thing. These are all the various rights, my lord, and they're already protected to a significant extent by the Contract Act or the Transfer of Property Act. There is nothing very spectacularly unique about, my lord, my house rent stipulation. It is there in every lease, it is there in every contract. And the question is, my lord, that when your lordships are interpreting a statute which is taking away a particular species of rights, how does that get construed in the context of acquisition, non-starter? How does it get construed in the context of taking away a right? There has to be, my lord, some connection between what is being taken away, to whom is it being given, and in what manner is it being given. And that is the answer to my lord's question, that Article 39B in my respective submission actually only talks about how the government of the day can give effect to anything that it wants to do, any policy that it wants to do. So, my lord, throughout the 80s, 70s, 90s, your lordships have seen a spate of nationalization judgments. In the past decade or so, my lord, hardly any nationalization of a very big scale happens. Post 1995, your lordships have seen there's more and more private-public partnership. Now, the way in which the government should be able to do some things in a given socio-economic condition cannot be circumscribed by either the Constitution or by your lordships. The free play in the joint that the government may need in today's condition may not require nationalization, may require public-private partnership. Now, this creates a number of sub-issues. To whom are we going to give these resources? How are we going to give these resources? So Article 39B talks about how the ownership and control of material resources of the community, such as airwaves, such as gas allocations, such as private forests, such as mines and minerals. These are all, nobody can claim immunity from those being taken away on the basis of some fundamental right to property. But once they belong to the state, in whatever way, how they are going to be given is Article 39B. And if it should not result in crony capitalism, is Article 39C. So the free play in the joint in Article 39B, which is how the parliament or the state wants to give effect to a particular policy by bringing in, for instance, auctions. Your lordships will deal with that issue. In the natural resources, the issue was clearly that, should we go for auction, or are there other ways in which the government can give away what are these material resources of the community? Your lordship said it's a case-by-case, very broad kind of a canvas on which the state has free play. You cannot prescribe only auction as the way, because that would be fettering it. Now, my lord, your lordships considered Article 39B in the natural resources reference. So Article 39B, my lord, is only this. It is only a leeway given to the government to do a thing in a particular way. Article 39C says that when you do that, it should not result in concentration of wealth, crony capitalism. That's all that Article 39B does. Anything more being read into Article 39B, my lord, is a burden which it doesn't need to carry. And my lord, the final respectful submission is only this, that please see the effect in this case. In the Malpe judgment, your lordships categorically held the predecessor act, 1947 act, to be violative of Article 14. There was no plea taken at that time that Article 31C is applicable. They could have been taken, they did not. Your lordships found that Article 14 is violated. The state made a concession that, yes, we are actually going to redraw the law and we'll take into account this judgment, obviously, and also the model law which is being discussed with the housing ministers. What they did thereafter was they came out with the 99 law. Nothing but old wine in a new bottle, the same degree of toxicity which was found unfit to be consumed by your lordships. And then, please see the mischief here. When the matter came up, the state now says, we are taking protection of Article 31C. And that is recorded in the order, my lord. There is another reference even in my writ petition. So, my lord, the point is, if 31A is going to be a shield against 14 and 19, even in cases like this, then, my lord, 39B is really in need of, my lord, insulation from the attacks of 31C. That's all.
Yes, Mr. Kunja.
Lord, at the outset, my lord, on 31C, at the outset, there is no resistance in assisting your lordships. But we genuinely feel that that question is concluded, and we may perhaps.
We argue that, that is concluded and therefore it doesn't.
My lord, would your lordships, my lord, consider giving me 10 minutes? Why, my lord? Only on 31C. Lord, we have prepared a chart. Just for a quick reference, my lord, and this would be really handy, my lord. Yes, and your lordships may go by the color because color has significance.
Red ones are right.
No, every title has different color, and the change made is in that color.
Right.
My lord,
So-
permits if 31C, if it's being argued, then let us open as
No,
petitioner.
I'm not arguing.
If-
I'm not arguing
Very
on merits.
good.
My lord, the first is as introduced, my lord, 1971 amendment. Correct, my lord? Then post Keshwanand Bharti, my lord, what happened was the blue part, my lord, Keshwanand Bharti title is in blue. Therefore, what happened is in blue, just for easy reference. And no law containing a declaration that it is for giving effect to such policy shall be called in question in any court on the ground that it does not give effect to such policy. Rest is upheld by Keshwanand Bharti, 13 honorable judges. Then comes 1976 amendment.
So in Keshwan, they said that the immunity which is given to even challenging the nexus of the law to Article 39B, that immunity is struck down.
Yeah, correct. Correct. Rest is specifically upheld.
42nd Amendment.
My lord, 76 amendment, my lord. Yep, yes, your lordships are right. My lord, that is in green, where instead of clause B and C of Article 39, the entire chapter 4,
All or any.
yes, my lord, or any principles laid down in part 5, and blue, my lord, continues from the previous. So your lordships are at this stage not concerned. Lord, kindly come to next. Then post 78 amendment.
Because 44th Amendment deleted Article 31 and 19(1)(a). So it was deleted from here also.
Therefore, my lord, the article only read, my lord, the title is read, and therefore Article 31 is deleted in here. Lord, now Minerva Mill strikes down, and what is struck down is, my lord, also struck down in my chart.
But in your chart, the last column, you've again put the words, the principles specified in clause B or C of Article 39. That is the part to be decided. That is the part to be decided,
You have
whether it is
inserted-
reversed.
I'm sorry,
you have inserted it.
In clause, in your last column, 1 through 3, 4th, 5th column,
yes, my lord.
what Minerva Mill struck down,
That's our case, and that is accepted by 5 judges.
all or any of the principles laid down in part 4, that is struck down in Minerva Mills.
Correct, my lord.
And therefore you have deleted it in your last column.
Correct, my lord.
But does that have the effect of restoring the words, the principles specified in clause B or
Whether
C?
the revival issue. Revive. Yeah, yes, my lord. That's my lord the content. So, my lord, according to us, this is how the
This is how it is to be read now. That's right.
31C, and that is how your lordships have,
Where you have inserted it.
no, not we can't insert. Here, yes, 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 yes. Yeah, your lordships are right.
But whether it is as a matter of law, constitutional law, whether this is the.
Your lordships have said so in a combination of 5 judges.
All right, now let's see that.
That's what, my lord, I'm saying. My lord, first kindly see, my lord, my note, my lord, which I used yesterday, volume 2B, my lord. Volume 2B, my lords. Lord, I skipped it yesterday, my lord. I'll just, my lord, highlight at the cost of repetition, saying that there is no resistance. But I'm just saving time, my lord. It's concluded by a 5-judge bench and not disputed or doubted anywhere subsequently. Lord, after I'll just read para 15.
Volume 2B page.
6, my lord. 6. PDF 6, my lord. The title is Issue Concerning Revival.
Yes.
Lord, your lordships may kindly bear in mind, my lord, the question which was framed in 31 with regard to 31C was a judgment of 3 honorable judges in 1980. Now, my lord, 1986, my lord, I stand corrected. Now we are in Vaman Rao, my lord. It is at the outset, it is submitted that the validity of the unamended provision in 31C prior to the 42nd amendment is no longer res integra. It is submitted that Article 31C was specifically upheld by the judgment of 13 judges in Keshwan and Bharti. The effect of judgment in Minerva Mills on the validity of unamended 31C post Keshwan and Bharti was specifically raised and rejected as far back as in judgment in Vaman Rao Supra. In Vaman Rao, a bench of 5 judges held as under. That leaves for consideration the challenge to the constitutional validity of unamended Article 31C. As we have stated at the beginning of this judgment, Article 31C was introduced by 25th Amendment. Initially, it sought to give protection to those laws only which gave effect to the policy of the state towards securing principles specified in Clause B and C of Article 39 of the Constitution. No such law could be deemed to be void on ground that it is inconsistent with or takes away or abridges the right conferred by Article 14, 19, and 31. The concluding portion of the unamended article, which gave conclusiveness to certain declarations, was struck down in Keshwan and Bharti in so and so. Sri M.N. Phadke, who led the arguments on behalf of the petitioners, built a formidable attack against the virus of Article 31C. But with respect to the learned counsel, the effort is fruitless because the question as regards the validity of 31C is no longer res integra. The opening clause of Article 31C was upheld in majority in Keshwan and Bharti, and we do not quite see how the petitioners can be permitted to go behind that decision. Then, my lord, again, a highlighted part. The question of validity of 25th Amendment, by which the unamended Article 31C was introduced into the Constitution, was specifically raised before the court, and the arguments in that behalf were specifically considered by all the 6 minority judges and Justice Khanna. It seems to us difficult in these circumstances to hold that no common ratio can be culled. But that was the argument, that because of various different judgments, common ratio is not possible. The court rejects that. It seems to us difficult in these circumstances to hold that no common ratio can be culled out from the decision of the majority of 7 judges who upheld the validity of Article 31C. Putting it simply, and there is no reason why simple matters should be made complicated, the ratio of majority judgment in Keshwan and Bharti is that first part of Article 31C is valid, Apart from this, if we are right in upholding the validity of Article 31A on its own merits, it must follow logically that unamended Article 31C is also valid. Unamended portion of 31C is not like an uncharted sea. It gives protection to a defined and limited category of laws which are passed for giving effect to the policy of the state towards securing the principles specified in Clause B or Clause C of Article 39. These clauses of Article 39 contain directive principles which are vital to the well-being of the country and the welfare of its people. Whatever we have said in respect of the defined category of laws envisaged by Article 31A must hold good, perhaps with greater force, in respect of laws passed for the purpose of giving effect to Clause B and C of Article 39. It is impossible to conceive that any law passed for such a purpose can at all violate Article 14 and 19. Article 31 is now out of harm's way. In fact, far from damaging the basic structure of the Constitution, laws passed truly and bona fide for giving effect to directive principles contained in Clause B and C of Article 39 will fortify that structure. We do hope that Parliament will utilize to the maximum its potential to pass laws genuinely and truly related to principles contained in Clause B and C of Article 39. The challenge made to the validity of first part of the unamended Article 31C therefore fails. My Lord, and my Lord, order of the court at page 8.
But therefore, they say that Article 31C as originally enacted was upheld by the judgment in Keshwan Bharati, except for that last part, the last portion. But they don't say that that original amendment, that the original position is revived after they struck down the amendment brought about by the 42nd Amendment. That declaration is not issued.
My Lord, that is subsequently in a judgment. Therefore, my Lord, I'm saying with a sense of responsibility, not to avoid, my Lord, addressing on that. My Lord, and my Lord, this judgment is after Minerva Mill judgment, after taking note of Minerva Mill judgment. Lord, please see.
Common Rao is after.
After, my Lord, yes, my Lord. It takes note of Minerva Mill and says that what will be the effect of Minerva Mill judgment in 31C.
Actually, the operative order was pronounced on the same day.
Lord, please see that order of the.
Vaman Rao, the actual reasons were delivered in November. I think Minerva came in August.
Yes.
July.
But it was specifically stated that this will go to May 8.
Yeah.
We read as May 8.
There is one
Both
thing.
of the same.
Lord, would your lordships come to page? I'm sorry.
This chart shows had made this provision by 76 amendment quite wider.
Yes.
Your amendment was the principles and all that, including this part 4. Part 4.
Entire passport, not just 39.
Part,
B and C.
these lines were struck down by the court.
Yes.
So how you can import the limited part when the wider is struck down?
No, limited was sustained, wider was struck down.
Wider was the wider goal.
But the brother is saying, how will it come back on its own?
That's why,
You would like us.
Lord, it was sustained in Keshwan Bharati, my Lord, that's what Vaman Rao.
Sustained in Keshanan, then section 4 of the 42nd Amendment substituted it completely.
My Lord, can your lordships,
Substituted section 4 was
Lord.
struck down in Minerva.
my Lord, if your lordship wish to go into it, we will go into it. My Lord, right? But kindly, my Lord, allow me, there is a last 5 judgment
Now,
which
tell us-
squarely deals with this.
Show us is from Minerva. What is the operative order? What is struck down in Minerva? Let's just see Minerva.
Lord, can I show, my Lord, this complete this?
Before that, just let's see what is struck down in Minerva.
Yes.
Let it be taken up. My Lord, I think, my Lord,
No, we
the-
want Minerva. What is the operative part in Minerva? That's all. Just show us that. It will just complete this process for us. That's all.
my Lord,
And
if
if
your lordship
my-
see, my Lord, that is there in page 7. That's what I'm saying.
Why don't you show us from volume
Well,
5?
I'll show it. My Lord.
Volume 5
in the
is
meanwhile,
Minerva.
if I may
Yes.
just point out one fact with my lord,
Point out
Justice Bindus, no, not my argument.
solicitors on his
Lodge,
side. Just tell us what is the page of the operative direction in Minerva.
2085.
Paragraph
2085.
Which volume is it?
Volume 5.
Volume 5, page 2085.
Yes. Para 70, my lord. 75, my lord, 75. Yes. Those then are our reasons for order, which we passed on 9th May, as my lord, the Chief Justice was, to the following effect. Section 4 of the Constitution 42nd Amendment Act is beyond the amending power of the Parliament and is void since it damages the basic essential feature of the Constitution and destroys its basic structure by a total exclusion of challenge to any law on the ground that it is inconsistent with or takes away or abrases any of the rights conferred by Article 14 or 19 of the Constitution if the law is for giving effect to the policy of the state towards securing all or any of the principles laid down in Part 4. So the entire directive principles of state policy. Yeah.
Of the 42nd Amendment.
Put your lordships.
1-4. Where did we get that page?
It's 2066.
2066.
Para 14.
May I assist your lordship and the learned solicitor general? Lord, the correct observation is para 58.
If you don't mind, I'll just conclude.
Question never, please specifies that.
2066. Correct.
Lord, I left my note, my lord, at a very crucial juncture, my lord. If your
We'll come back
lordship
to- No, we'll come back. to
would
it.
have seen
This
the
para
operative
14
part of Vaman Rao, my lord, would have assisted, your lord.
We'll just look at this and then go to that.
Yes, my lord. Para 14. Section 4 of 42nd Amendment, which was brought into force with effect from January 3, 1977, amended Article 31C of the Constitution by substituting the words and phrases all or any of the principles laid down in Part 4.
That is
For-
that's a little bit of a ticklish issue because it substitutes all or any of the principles.
No, that is considered, that
Does
issue is, but that issue is considered by a 5-judge bench.
All right. Now
That's
we'll
what
go back-
I want your lordships
We'll
to
go
see.
back to your note, yes.
Yes, ma'am. Lord,
Since we have
page
opened this.
7, page 8, page 8. Lord, PDF page 8, Vaman Rao. E,
2B.
Roman 2B, short note on behalf of SG, my lord, and it's page 8. Look, this is the order of the court. My lord, this is quoted by me.
Is when you're opening a new.
We'll have to. I feel, my lord, your lordships.
I think the logistics about opening multiple windows, that's all. Nothing else.
No. My lord, order of the court, page 8, my lords.
Page.
Page 8, PDF 8, note, my lord, volume 2B.
Page 8, para.
The order of the court.
Oh, order of the court. Yes, yes.
This is not my words, my lord, that's how it is recorded in the judgment. Article 31C of the Constitution, this 5-judge bench in Vaman Rao. Article 31C of the Constitution, as it stood prior to its amendment by Section 4, there is a declaration, yes. And thereafter NGSC. After considering Minerva, Vaman Rao, my lord, the judgment says this. The Article 31C of the Constitution, as it stood prior to its amendment by Section 4 of Constitution 42nd Amendment Act, is valid to the extent to which its constitutionality was upheld in Keshwanand Bharti. The revival declaration. Lord, as my learned friend Mr. Shankar Narayan rightly says, that if a player is on the field, you send a substitute. Substitute goes, the player also doesn't go, but simultaneously. He remains. As it stood prior to so-and-so, Article 31C, as it stood prior to Constitution 42nd Amendment Act, does not damage any of the basic.
Tell us, Mr. Solicitor, when a constitutional provision is amended by substituting a new provision in its place, does the original provision stand?
Yes, ma'am. That is what was again considered.
This is their entire argument, that it doesn't.
When a constitutional provision is substituted by a fresh provision, the fresh provision comes into force instead and in place of the original provision. Right? Now, if the validity of the fresh or the amended provision is struck down, on what theory of law does the original provision get revived? That's the point.
Would your lordship see, my lord, the NJSC judgment, again a 5-judge bench, where this question is squarely raised?
Now, since you are on Vaman Rao, remember Mr. Nariman had argued that, well, Vaman Rao proceeded on a concession by Mr. Palkiwala. Where is that concession recorded in Vaman Rao?
Not in Vaman Rao, my lord, that's in Minerva.
Assumption is where? In Minerva and Vaman Rao?
Vaman.
That's Mr. Nariman's argument.
In Minerva, in Minerva.
That's his argument. That's not what is held. But Mr. Nariman's argument is based on which part of the judgment? He said that Mr. Palkiwala conceded this position. Now, where does Mr. Nariman get that from?
There's no concession.
Probably that is in.
That is in
Sanjeev
Sanjeev
Koch,
Koch's
Sanjeev
problem.
Koch.
That is probably in that case. When Minerva Mill has been discussed by Justice O. Chinnappa Reddy, and then there is something.
Now, NJSC, where do we get? Yeah, that's right.
Yes, my lord, kindly have come to NJSC. NJSC squarely this, the my lord, question which fell from my lord, the Chief Justice, my lord, was raised.
Check up somebody.
In the meanwhile, no, we'll do that.
Where is it?
Volume,
Yeah, it may be in.
volume. NJSC.
After it says that we are perplexed, something like that.
Huh?
We are perplexed.
Yeah, your lordship.
The judge says that,
The-
we are not saying it.
In Sanjeev Koch, they have said that bench was perplexed.
Perplexed by this.
Judgment in Minerva Mills,
Yes.
And then it comes.
not us.
Yeah, your lordship will never be perplexed. A page number? Lord, please come to volume 5, NJSC judgment. This contention was raised.
Which page?
Lord, page 3877, my lord. Para 408. There is a title given in the judgment.
Mr. Solicitor, that argument of Mr. Nariman's, which is referred to in the first referring order, was on the basis of Minerva. Because I'm now at volume 5, page 2790.
Correct.
Where he says they record Mr. Nariman's submission, volume 5, page 2790. He contended that the decision in Minerva Mills proceeded on the basis of a concession made by Mr. Palkiwala and on an assumption that Article 31C, as it survived as a result in Keshwan and Bharti, stood revived after the subsequent events. That's what that seems to have been his submission at that point.
Yes, my lord, your lordships are on page 2790, my lord.
790.
Para 5.
Para 5, Mr. Nariman's submission.
My lord, I would, my lord, speaking for myself, my lord, when Nani Palkiwala gives some concession, my lord, on the basis of Keshwan and Bharti, my lord, I would respectfully buy it, my lord. There must be a good reason not to. Yes, my friend, my lord. Para, my lord. No, para. 2069, my lord. But possibly it's not concession. Para 24, my lord.
It's 5.
This is Minerva Mills. Possibly the paraphrasing by Mr. Nariman, my lord, appears to be a little inaccurate. It was not a concession.
It was the para in Minerva page.
My lord, page number 2069, para 24. Does my lords get, my lord?
Yes.
The next question which we have to consider is whether the amendment made by section 4 of the 42nd amendment to Article 31C of the Constitution is valid. Mr. Palkiwala did not challenge the validity of the unamended Article 31C, and indeed that could not be done. The unamended 31C forms the subject matter of a separate proceedings, and we have indicated therein that it is constitutionally valid to the extent to which it was upheld in Keshwan and Bharti. It was neither on assumption or concession. But possibly Mr. Sirvai in his book writes, but possibly Mr. Sirvai in his book writes that this was a concession. Possibly, well, that's from where, my lord, Mr. Nariman, my lord, the learned counsel, Mr. Nariman. It's a statement of fact, my lord, not a concession.
Yes.
Now, my lord, may I come to my lord NJSC judgment?
NJSC, now where is NJSC?
3877 at 3877. Same volume, my lord. This is, my lord, majority view of my lord Justice Kehar. And on my lord, similar view is taken by Justice Joseph also. Which is the para number? Let's see. $255, similar submission is raised, my lord. I'll just, my lord, come to that. But please see 5, the effect of striking down the impugned constitutional amendment. Does your lordships get, my lord? Would the amended provisions of the Constitution revive if the impugned constitutional amendment was to be set aside as being violative of the basic structure of the Constitution, it would be relevant to mention that the instant issue was not adverted to by the learned counsel for the petitioners, possibly on the assumption that if on consideration of present controversy, this court would strike down the Constitution 99th Amendment Act, then Article 124 so and so, as they existed prior to the impugned order, would revive. And on such revival, the judgment rendered in the second and third judges' case would again regulate selection and appointments, as also transfer of judges of the higher judiciary. A serious objection to the aforesaid assumption was raised on behalf of the respondents by the Solicitor General, who contended that striking down of the impugned constitutional amendment would not result in the revival of provisions which had been amended by Parliament. My lord, contrary to what I'm urging now was the argument that it doesn't revive. In order to canvass the aforesaid proposition, reliance was placed on Article 367, which postulates that provisions of the General Clauses Act had to be applied for an interpretation of the articles of the Constitution in the same manner as the provisions of the General Clauses Act are applicable for an interpretation of ordinary legislation. Insofar as the instant submission is concerned, we have no hesitation in affirming that unless the context requires otherwise, the provisions of the General Clauses Act would apply. Now kindly directly see 3886. But I'm sorry, my lord, my learned wants me to come to 3813 first.
38?
Based on, my lord, what? 3813, my lord. Para 255.1. These very proceedings were relied upon by, my lord, my worthy predecessor, the learned Solicitor General. Your lordship gets, my lord? This is the same judgment, NJSE. The contention is noted.
Property owners.
Yes, madam. Firstly, that the issue whether a constitutional amendment once struck down would revive the original substituted article was a matter which at 255.1, madam. Page 3813. So please see the last sentence, my lord, of this. After quoting, my lord, the judgments, Property Owners Association, my lord, all three Property Owners Association, respective references. It was submitted that the order passed by this court, am I with your lordship, my lord? Order passed by this court wherein the reference to a 9-judge constitution bench had been made was a case relating to constitutionality of Article 31C. It was pointed out that Article 31C, as originally enacted, provided that it was submitted that the later part of 31C, which provided and no law containing declaration that it is for giving effect to such policy, shall be called in question in any court on the ground that it does not give effect to such policy, has been struck down by this court in Keshwanand Bharti case. It was contended that when the matter pertaining to the effect of the striking down of a constitutional amendment had been referred to a 9-judge bench, it would be improper for this court, sitting in its present composition, to determine the aforesaid issue. So, my lord, the request was that on this issue, you kindly refer it to a larger 9-judge bench. And, my lord, now the answer, my lord, at page.
And then 255.2.
Yes, I'm sorry, my lord.
This is a submission of the Solicitor General.
Yes, my lord. The second contention advanced at the hands of the learned Solicitor General was based on section 6, 7, and 8 of the General Clauses Act. It was contended that an amendment which had deleted some part of the erstwhile Article 124 of the Constitution and substituted in its place something different, as in case of Article 124 of the Constitution Act, 99th Amendment Act, would not result in the revival of the original article which was in place prior to the constitutional amendment. Even if the 99th Amendment itself was to be struck down, it was submitted that if a substituted provision was declared as unconstitutional for whatever ground or reasons, the same would not automatically result in the revival of the repealed provision. in order to support the aforesaid contention, reliance was placed on so-and-so, 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 my lord. It was submitted the general rule of construction.
No, you go by this.
Lord, now please come to, my lord, page 3877.
Read actually. Yes, we-
I'm just, my lord, trying to point out, my lord, that there was a suggestion that in a combination of 5 honorable judges, revival question be not decided, because this reference, this particular present reference is referred to a 9-judge bench, and it does not stand revived. That was the contention. My lord, I have read para 408, 409 under the title, Effect of Striking Down of the Impugned Constitutional Amendment. Now, please, my lord, directly come to page 3886.
Page
3886. My lord, all the judgments, my lord, which the learned Solicitor General, my lord, the then Solicitor General, my lord, referred to and relied upon were discussed. And my lord, after the quotation of the judgment, after classitum D, what needs to be noticed, does your lordship get, my lord?
Yes.
What needs to be noticed?
Page 3886. 3886.
My lord, may I read? Your ladyship gets, my lord.
886.
3886, after the quotation of the judgment relied upon, just below classitum D. What needs to be noticed from the extract reproduced above is that this court, in the above judgment, clearly concluded that the legal effect on an earlier law, when the later law enacted in its place was declared invalid. Lord, may I continue, my lord, and after that?
Yes. Their argument.
could not become effective without the assent of the Governor General. The state governor's assent was insufficient. It could not be inferred that what was intended was that in case the substitution failed or proved ineffective, some repeal not mentioned at all was brought about and remained effective so as to create what may be described as a vacuum in the state law. So maybe vacuum or not is not the question at all. Question is substitution is an amalgam. It repeals and replaces something. So it can't be that in part it is struck down, gone, but the repeal part remains. That's what this judgment said.
It was never there. It was never born because assent was not there.
No,
In this case, it came into effect, substitution was done, and then declaration.
no, the point is that once your lordship declares the substitution itself to be void. See, what are we reading? How do we read section 4 now? What are we reading? We are reading it as if section 4 have those struck down as void in Minerva, yet the substance of the amendment goes, the old doesn't revive, so it's a repeal. So the repealing effect is surviving. The repealing effect of section 4 is surviving. Therefore, notwithstanding the declaration that it is void. How can that happen, my lord? We are splitting up the declaration of the court in Minerva Mill. Part is void, part is surviving. Section 4 reads, this will be substituted. 4 is gone. So where is the substitution? So in a matter of substitution, it's an amalgam. The going out and the coming in are one intertwined act of the legislature. The whole goes. Unless the court splits it up, having found that it is severable, then of course your lordships can say that we are striking down this part of it, but we are not reviving. That the court never said. It declares the whole entirety of section 4 null and void. So it can't have a split effect. But the third thing was, I'm not elaborating. I have numerous judgments which I can cite, but I'll do it when my turn comes. But the third and more important is, what is this doctrine of basic structure under 368? The doctrine is that if you damage the basic structure, then what you are doing, your act is beyond your competence under 368. So the amendment which brought about the enlargement is been held in Minerva Mill to be beyond the competence of the parliament under 368. So what is beyond the competence, my lords, cannot have any effect at all. It can't be that it was beyond the competence, yet in part, in some little part, it is still surviving to have the repealing effect of what was upheld by 13 judges. And it has dangerous consequences, as what the learned solicitor said, which a lordship, of course, will elaborate what all can be amended. And then, my lords, every time this court will be, my lord, be troubled with this. How much of it is, my lord, reviving or not reviving? In my submission is quite contrary to Mr. Nariman's. He says, refers to that expression, stands part of the Constitution. That's what in Article 368 is, that once the bill is passed, it stands amended in terms of the bill. But he misses the expression which is earlier. Once it is passed and assented thereupon. Now, if it could not be passed, once it is void, it could not be passed, it could not be assented. So there's no question of the thereupon effect following. That is stands part. Merely because the ultra-virus declaration comes, my lord, after a decade, it doesn't mean that it was the last 10 years competence. That's the thing.
Can I just take 2 minutes? I'll just.
We'll now hear everybody later. Mr. Andarujana.
No, I'll just supplement 1 minute.
Two dates. Get your full turn now. You get your full turn. There were 3 counsel on one self-evident proposition. Now, Mr. Andarujana.
Only 2 dates.
Let him argue.
2 dates.
In response, yes. Mr. Andarujana, please start now.
First of all, Lord, I want to express my gratitude to your lordships for taking up this point, Lord. But it is an important point, a point particularly important for the facts of this case. Lord, I fully understand the concerns expressed by my learned friends, Lord, the Solicitor General, the Attorney General, Mr. Dwivedi. But regretfully, my Lord, I disagree with almost every statement of law that they have made. Lord, Mr. Nariman's point, Lord, in my respectful submission, is a point which carries great force and a point which requires a determination by your lordship's bench. Now, Lord, I have divided my arguments, Lord, into 4 segments. but I'd just like your lordship broadly to know how I wish to address your lordships today. Lord, I will just frame the issue before your lordship precisely because I think, Lord, it is important that we understand that we are dealing with the effect of a declaration of unconstitutionality on a substituted provision in the Constitution. And that is the precise issue. But I'll just frame it in a moment for your lordship.
Just
And I will
the effect of the declaration of a substitution, declaration of unconstitutionality.
Yes,
Just one second.
yes, Lord.
Effect of the declaration of unconstitutionality on a substituted provision.
In the Constitution. And my lord, and I think it is important, my lord, that we bear in mind the distinction of this issue from other legislative activities such as repeal and introducing the laws. Lord, it's an important distinction to be borne in mind in my respectful submission. My lord, I hope that I will persuade your lordship, so that is the case. My lord, my lord, the first part, my lord, I wanted to address your lordship on, my lord, which will nail, my lord, to the mast, my lord, with some certainty. My lord, what exactly factually took place? My lord, so much will become evident from that, because I will show your lordship that for 20 years, in fact, for about 22 years, my lord, there was no Article 31C did not exist in the Constitution at all. It came in later. Lord, I'll also tell your lordship, Lord, in a nutshell, my lord, about the reasons for introduction of Article 31C. Lord, there is no constitutional chaos which is going to result, as your lordship alluded to, for different reasons. Lord, I also want to set out, my lord, how the Minerva Mills judgment came to be. And I want to point out to your lordship that actually the problem is a problem post Minerva Mills. So it is a problem post 1980. So Lord, if we bear that in mind, but the issue that we have is a post 1980 issue, but that will all become evident, my lord, in my legislative history. Lord, the third issue which I want to address your lordships on, so the first was to frame the issue correctly. My lord, the second, my lord, was to deal with legislative history very swiftly, my lord. I won't take your lordship's time on that. And my lord, the third, my lord, I wanted to deal with the effect of Lord Minerva Mills, Vaman Rao, and the successor judgments. My lord, there are in particular two, my lord, Sanjeev Coke Mills, Sanjeev Coke, and the other one is the Bhim Singh Ji judgment. My lord, and also, my lord, there's another judgment called Basanti, my lord, which actually dealt with a 31C challenge to MHADA itself, where also, my lord, 31C was noticed and the learned judges proceeded on the basis that in fact it was valid. So, Lord, I'm going to show your lordships all of this. Lord, I hope to immediately and swiftly show your lordship that Minerva Mills clearly proceeded on a concession which was made by Mr. Palkiwala, Lord, who was arguing the case. But the issue, in fact, never arose in Vaman Rao, which will also become evident from the dates in my legislative history. It could not have arisen because the question of striking down was not before the court in Vaman Rao at all, for that simple reason. But, Lord, I hope to elaborate on that. Now, Lord, I also, Lord, in the next segment of my arguments, Lord, want to deal with the NJAC judgment because, Lord, it is, I did find it, Lord, curious that my learned friends relied upon it because that judgment, Lord, was a judgment I wanted to rely upon. Lord, it entirely, in my respectful submission, Lord, supports my arguments, as I will show you, Lordship. Lord, and it distinguishes, of course, that amendment as saying that that amendment was not a substitution. Well, that really, my lord, is the short point with regard to the NJAC judgment. I hope to make that good. And it otherwise, my lord, fully accepts, my lord, the submission that in fact there is no doctrine of automatic revival. My lord, the last part of my address, my lord, is on the consequential aspects in the event that I am to succeed. My lord, there will be no, my lord, constitutional chaos. There will be no crisis, as I will show your lordship. And to your lordship's very pointed question about whether this is purely a technical point, in the sense that Parliament can always step in and take the necessary steps to redress it, or I'll make a few comments on that. So, my lord, that is how I propose to go about this. My lord, my time estimate, my lord, is approximately 2 to 2.5 hours, if your lordship will permit me that. Lord, so, Lord, I will straight away start. My lord, by, if your lordships don't mind, my lord, I have prepared a note on this. My lord, I have prepared a note on this. My lord, the note is actually what I gave your lordship yesterday, and the same note from which I argued the Coelho point. My lord, today, my lord, I will be relying on serial numbers 1 and 3. My lord, the note has an index in front, if your lordship will see it. Or it has 3 items, but Roman 1 is legislative history and Roman 3 is whether 31C is a dead letter. But my lord, before I go to the note, my lord, I wanted to give your lordship, my lord, a brief overview of the legislative history. My lord, it is not even necessary to read this note. My lord, I think I can effectively bring it out in a few minutes before your lordships. Or do your lordships have the note, just so that...
It's one.
Where is your note?
My lord, it's 1B in the Google Drive, 1B.
Volume 1B.
Lord. The name is note tendered by Mr. Zalti on the original, senior advocate.
I've got a lot of.
Legislative history of Article 31C.
Yes, no, my lord, it says, yes, legislative history of 31C of the Constitution is the first item, relevant to the present case. It's not a general history, my lord, relevant to the present. But if all of your lordships have it,
Just 1 second.
yes, please.
I have one which is garbled, the garbled version. Let me see.
Please. Other interesting developments. Lord, on item 18, so Lord, once again in 1980, we have 3 very, very important judgments all dealing with Article 31C. We have the third of those judgments, Lord, which is on 13th November 1980, the order passed in Bhim Singh Ji's case. Now, Bhim Singh Ji's case.
Remember comes Bhim Singh Ji.
Yes, Bhim Singh Ji. Now, my lord, Bhim Singh Ji's case was the case which was referred to by my lady yesterday, Lord, in the context of the urban land sealing challenge. As my lady knows, my lord, in Bhim Singh Ji's case, the result of the majority was to strike down only one section, which was 27(1). But Lord, the effect of Bhim Singh Ji, Lord, is a very neutral effect on this argument, Lord, for reasons that I'll come to when I deal with the judgment individually. Now, Lord, your lordship will only note, my lord, relevant to the facts of this case. Item 19 on 26 February 1986, Chapter 8A of Madar is now introduced. So, my lord, just to contextualize it, my lord, to the facts of our case, Lord, this happens there. And, my lord, sorry, I seem to have omitted to mention to your lordship one relevant date, my lord. Item 16, I'm afraid I failed to read that, my lord. Lord, if your lordship will see the note, Lord, the judgment in Minerva Mills also referred to Sanjeev Coke. Lord, note 2.
Coke referred to Minerva Mills.
Yes, sir.
The reverse.
Yeah, the judgment in Minerva Mills was referred to in Sanjeev Coke.
I'm so sorry. So Sanjeev Coke is the other judgment which also deals with this 31C. My apologies, Lord.
Right.
I misspoke. So, Lord, we have Sanjeev Coke, then we have Bhim Singh Ji's case. We then have the insertion, Lord, and then, Lord, if your lordship will just kindly turn to Lord, just there is one more date which I want your lordship to have. I'll just give it to your lordship presently, my lord. The order in yes, my lord, that is 1986, the exact date.
86 to
1986. 13th March 1986.
Right.
And then we have finally, my lord, to conclude this, the order of reference from 3 judges to 5 judges on this issue.
And we have seen.
1st May 1996. So, my lord, that is how the issue now arises before your lordship.
Right.
But may I now show your lordship, Lord, the Minerva Mills case?
Yes.
And then I will like to show your lordship Vaman Rao, Lord, before we move further. Lord, so if your lordship doesn't mind, Lord, Minerva Mills. Lord, your lordship will find that at page 2050 of the precedence compilation which your lordships have. But we are principally concerned here, my lord, with the majority view. But my lord, Justice Bhagwati actually, my lord, does something quite unusual. My lord, Minerva Mills, he also deals with Vaman Rao. So, my lord, may I refer your lordship first in Minerva Mills, my lord, straight away, my lord, to the question for consideration. And that your lordship will find at page 639. Sorry, internal 639, which is 2064. Your lordships have that, my lord. Yes, my lord, your lordship is right, and it does add a slight complication to the matter. But I believe what
It refers to Vaman Rao because Vaman Rao was pending at that time.
Not so the curious, but in one sense, it comes down to Keshav Nanda.
The reasons had come in July. The operative order in Vaman Rao had been pronounced. May. So they knew that they had upheld the constitutional validity of the unamended 31C in Vaman Rao. The reasons were to follow later in November.
But I would add to that a little bit, Lord. In fact, if your lordship sees the order in Vaman Rao, it's not exactly in line with the reasoning in Vaman Rao. If your lordship just comes back, the reason why they said this.
It's a conundrum, because while Minerva sets aside the entirety of Section 4, Section 4 comprises a smaller subset which has been upheld in Keshwanand. The bench in Minerva did not have the ability to say that it was severable, because the severability would not arise, because it was one amendment, it was one substitution, it was composite. Otherwise, they would have severed it. They would have said what has been upheld in Keshwanand, we can't strike it down, but they didn't have that choice here because it was one composite amendment. Otherwise, they could have applied the test of severability. But when you apply the test of severability, something which is valid has to survive. Here, they could not apply the test of severability because it was composite. So, in a sense, that was intellectually the problem which the bench was facing. I mean, they don't articulate it in that way, but obviously it's clear. That was therefore, they strike down the entirety of Section 4.
Lord, may I add to, but I am complete respectful agreement with everything that your lordship said. And Lord, I'm glad that your lordship said it rather than I saying it. But Lord, may I add one or two things that I could say about it, Lord. If your lordship were to see the order in Vaman Rao, it actually says this. The reason why they actually repeated this in Minerva Mills was that the order in Vaman Rao, which was available by the time that the judgment came in Minerva Mills, for which your lordship will find conveniently at para 15 of my list of dates, page 19. But it says this, but I'll just read your lordship again. 31C as it stood prior to its amendment is valid to the extent to which its constitutionality was upheld in Keshav Nanda Bharati. So the reason why, Lord, they used this very language in Minerva Mills was this was the order in Vaman Rao. But what this meant was actually explained by the judgment in Vaman Rao. But I'll just come to the judgment in Vaman Rao in a minute. Lord, Vaman Rao, Lord, decided on independent reasoning, not on the doctrine of precedent and Keshav Nanda Bharati, but arrived at the same conclusion. So, Lord, that is how this statement comes to be a part, and that is the correct meaning to be ascribed to the latter part of this concessionary statement.
But then, if Vaman Rao independently uphold the unamended 31C,
yes, Lord.
Right? Does it hold it only for the period prior to the 42nd Amendment, or does it then, is it capable of the inference that, well, that the unamended 31C survives The striking down of section 4 in Minerva.
So, my lord, your lordship has once again, my lord, rightly identified the complication. My lord, as soon as we deal with Minerva, my lord, permit me to go to Vaman Rao. But would your lordship mind if we just finish with Minerva once?
We saw para 40 for 24. Let's go ahead. You can go in
So,
here.
24 is a para, my lord, of considerable importance.
Para 25 also.
25.
Yes, 25. But of course, not the whole judgment, my lord, is
Zal, you can read para 24.
24 again, please. Or I'll read it slowly. The next question, which we have to consider, is whether the amendment made by section 4 of the 42nd amendment to Article 31C of the Constitution is valid. Mr. Palkiwala did not challenge the validity of the unamended Article 31C and indeed could not be done. Now, why could it not be done? The unamended Article 31C forms the subject matter of a separate proceeding, and we have indicated therein that it is constitutionally valid to the extent to which it was upheld in Keshavananda Bharati, and the asterisk takes us.
It's not a
It
concession.
is not a concession at all. It is because there is already a decision of Supreme Court
Yes.
which has upheld the validity of
In Keshwanand and independently in Vaman Rao.
It's an authoritative pronouncement.
It is an.
No, I accept what your lordship say. Lord, that yes, it was not Mr. Palkiwala made the concession, but the judges said that on the basis of the concession and on this basis, in fact, the concession was unnecessary because Vaman Rao had already decided this one. But I
Will it be also right to say that it was a concession by Mr. Palkiwala? Mr. Palkiwala, he said that he did not challenge it. That doesn't mean that, you can put it as if there was a concession made.
he stated the correct position of law. This is what has happened.
So, my lord, yes, your lordships may well be right, my lord. That also works for my argument, my lord. I don't need to dispute that. Yes, my lord, it could well be that what Mr. Palkiwala said, that in view of the order now which is passed in Vaman Rao, I don't need to challenge it, albeit, my lord, I may respectfully differ from your lordship for this reason. But consider the timeline. My lord, at the time when the matters were being heard together, the order in Vaman Rao was not out. During the course of the hearing, the order was not out. My lord, so Mr. Palkiwala, my lord, would not have been able to, my lord, know that in Vaman Rao this would have been the case. But by the time that the judgment is delivered in Minerva Mills, the order in Vaman Rao is out. So the judges have the advantage of that order. So, my lord, but the way that I read this, my lord, given this context,
It's almost 4 o'clock, but the only point which we'll have to consider is this. You can reflect on it.
is
The net result of Vaman Rao and Minerva Mills is this. Vaman Rao upholds the unamended provisions of Article 31C on reasoning independent from that in Keshwanand.
well,
The amended provisions of section Article 31C, as amended by the 42nd Amendment, are struck down in Minerva Mills. Now, does Vaman Rao really mean that the unamended 31C is upheld only prior to the date of the insertion of the substituted provision by the 42nd Amendment? Or does the unamended 31C continue to operate both before and after Minerva?
your lordship has put the problem perfectly, actually. Your lordship does know, I think, that my answer would be the first. But, my lord, I'll deal with it, my lord, at some length tomorrow.
Is that clear? Because then what was the purpose of Vaman Rao? Because
Yes.
see, the unamended provision of 31C had already been upheld in Keshwanand. Right?
Right.
Now, Vaman Rao, they had to deal with, why would they write a judgment in Vaman Rao?
Yeah, my lord, I will show your lordship. Yes, sir. But let me not say anything, my lord.
Benefit of Minerva. They mentioned.
But I'll address your lordship on this tomorrow.
Because see, Vaman Rao, conscious of the fact that they have struck down section 4 of the 42nd Amendment, yet proceeds to hold that the unamended 31C is valid.
That's correct.
Is that not therefore susceptible of the inference that they treated 31C to be continuing in operation, though in its unamended form, post the decision in Minerva.
But I will reflect on that.
Just reflect on it, Mr. Darshana. We'll continue tomorrow morning.
Deeply obliged.
Let's see what was the nature of the challenge in Minerva. You've shown us para 1. With the nature of the challenge in Vaman Rao, we'll also reflect on it in the evening and in the night today and look at it.
Certainly. Deeply obliged.
और आप हमसे जुड़े रहने के लिए सब्सक्राइब करें YouTube पर, फॉलो करें Twitter पर और लाइक करें Facebook पर और ज्यादा